told me apparently. Okay, so. Hey, what's up?
Mr. Noone, I have received your Rule 1.3D statement. I assume that you just handed a copy to the state, is that correct?
Yes, that's correct, sir.
Attorney DeJoy, do you know of any reason why I shouldn't statutory presumption of extremism versus permitted to appear on behalf of the
For the recollection that the state hasn't been able to perform a record check on this with regard to the document.
So I will permit Mr. Noone to represent Ms. Balding as her attorney. That means, sir, I'm going to hold you, as I said, to the same standards as any other. We're going to take the remaining preliminary motions in order, and then we'll go from there. Attorney DeJoy, let me first ask you, did you receive all of the motions that were filed?
And just to confirm what those motions are, I have a motion for change of judge, a motion for exculpatory evidence, a motion to eliminate and remand for trial by the judge for 20 years, and a motion to strike/dismiss and request for full finding of fact and conclusions of law.
Those are what the court has.
With respect to the motion to eliminate, the motion to
Hold on, Attorney DeJoy. I think the first thing we need to address, do you have any argument on the motion for change of judge?
Your Honor, I don't believe that there have been any facts put forward other than the denial of the motion that would require the court to do this.
And did you want to be heard further beyond the proceedings on that one?
Yes, please. I also have
No, don't call this
a
one.
witness that's subpoenaed, just text message him. That would be Matt Friend, Chief of Police, Medical Police Department.
Let's start with the motion.
He's
Make
funny.
those motions first. We can talk about anything else. That's a motion for change of judge. Anything you want to say beyond what's in your pleadings, which I did review this morning.
Oh, that guy's father.
Right. Yeah. This is in reference to
So that's it.
the
Yes, it must be. No, you're right. No, I'm not. Oh, no, I'm not.
We hereby move this court to qualify Judge Ryan Recusal. That's the correct way to say it.
So let me just pause one second. I have your pleading in front of me. I read it this morning. So is there something beyond what's written down that you want to tell me about this?
With respect to this order on defendant's motion to dismiss, I have some notes written down here. In this motion to dismiss, at the very end, it says, defendant argues state is unable to prove charges against her based on facts in the case. That is an issue that can only be resolved at trial. Based on what I understand about the courts, that is often put out there, and then when it comes to trial, I've observed that it says, oh, sorry, that was a free trial. been motions for a pre-trial hearing to hear, these matters. Probably what, for, like the motion and, other, motions before the court. As we are, farmers are extremely busy this time of year, and, we just can't stop our work or we have an economic failure in our family. So preparing for this has been, difficult. We've had to do a lot of research, confer with a lot of people, on how to go about this. And, we feel like we're being rushed to trial, being forced today to come here for trial and not a pre-trial conference to hear, motion, properly. Like there's, a lot of, elements that,
No, it's my water bottle.
we need to have the
So
original.
yummy. Look at the garbage. I'm gonna this is water there. Yeah. It makes sound. It can.
Anyways, so in the, motion to dismiss, we state that, I might state it wrong if I don't have it right in front of me, so I'm gonna, so look at that. In your work here, you have, cited certain, court cases, State versus Fortner, which seems to be, one of the, leading court cases that actually, it was, sort of the particular, charge that's being charged against my wife, is based on, from what I understand, State versus Fortner, has to do with a dead 18-month-old girl. There being an actual injury in a victim.
Is it?
I just wanna bring you back to, just wanna address each motion in turn. So, is there anything else you wanna say with respect to the recusal motion for change of judge?
I just feel that, you're not impartial because you have, you dismissed our, motion to dismiss without the prosecution even answering it. I feel like you took it on their burden, as the burden of proof is on the prosecution to, prove, facts and evidence that have to do with jurisdiction. And also, I don't believe that you understood where I was coming from. I'm not a lawyer, I don't exactly speak your guys' language. I try my best. Sorry, I sort of lost my train of thought here. But in this, motion, like I said, we're not prepared for trial. And also, I feel you're not impartial because basically you took on the burden of proof in that order to dismiss for the prosecution. The prosecution didn't even answer it, based on what I can tell in the, court docket, because after I got this order, I came, this order here, I came, went to the clerk's office, and there was no response from the, prosecution. So it essentially, the prosecution was unresponsive, and I feel, well, it appears to me that, you took on their burden and just, stated that the court has jurisdiction. I also believe that there was a miscommunication, on my part. You understood it as I think you understood it as I was challenging the geographical jurisdiction of the court. And at the end of this, we'll say,
I can stop it again. Oh!
and also this, I'd like to take a minute to confer with counsel.
You are the counsel.
I have other counsel here, as allowed by the Constitution.
everyone else has filed an appearance. I'm not going to allow more than one person to represent Ms. Balding today unless we have more than one appearance. So
I'm not looking for anyone to represent, Ms. Baldwin. I'm looking to, confer with counsel. If I'm being denied our right to confer with counsel, I object. Please note the objection for the record. I simply need to confer with counsel.
I'm ready to rule on the motion for change of judge. The motion is denied. The reason is in large part I'm citing the capital case 162, New Hampshire 285. That case states that in almost all cases, disagreement with the judge's rulings is not a grounds for recusal. You certainly appeal if you believe I've gotten the law wrong, but you're not entitled to a change of judge unless you can demonstrate facts which to an objective observer would raise a substantial doubt as to whether fairness will be done. Nothing that you cited and nothing in the record in this case rises to that.
I object, sir. If you could note that objection for the record.
And it's so noted, and just procedurally, there's no, if you object or you make a motion that will rule against you, you don't need to object again to preserve it.
Okay, thank you for that information.
So, the next motion I want to address, because I think it's preliminary, is the demand for a jury trial. And let me just inquire of Mr. Noone. So, are you familiar with New Hampshire Rule of Criminal Procedure 21A1 or 2?
I am not.
So that rule states, so this is a Class A misdemeanor, which means that Ms. Balding is entitled to a jury. Under our rules, there's two ways to exercise that right under our statute. So Class A misdemeanors, unless they're tied to a felony, they're brought initially in circuit court, which is here. Two ways to exercise the right to a jury trial. One is the procedure under 21A1, by which Ms. Balding would essentially waive her right to a bench trial today. The state would make an offer of proof. If I found that was sufficient to enter a finding, I would enter a finding of guilt. I'd impose sentence, and then your case would be immediately appealed to Superior Court for a de novo trial before jury. De novo means starts all over again. The jury would never be told that there was a prior finding. The second way to exercise the right to a jury trial is to have the trial here. If there were a guilty finding, you would be able to orally, right, at the time the sentence is imposed, say, I want to appeal to the Superior Court, have a de novo jury. And check a box on the form, case is sent over to Superior Court for trial automatically. You can also file a notice in writing within 3 days after sentencing. So absolutely you're entitled to a jury trial. There's two ways to go about it. One is to do two trials, one here, and if the outcome is not the way it will be, they go to Superior Court, or the other is to essentially have just a brief offer, an offer of proof. He just tells me what he thinks they can prove, and then you go automatically. I'll give you a moment to confer with Ms. Balding as to if you'd like, which of those options you'd like to exercise.
I have a question.
Okay, sure.
The option of going through with the trial, essentially, we request a jury trial.
The cost for exercising your right to a jury trial.
All right, well, that's acceptable. We're gonna continue here with,
Turn to.
I'll go static.